Hi, this is Alan Gassman, and I'm here with my friend Barry Flagg in the Gassman Studios. And we're here today to talk about New York's best interest rule for life insurance and very important implications for everyone in the country with respect to these rules. Before we get started, though, please remember to join us Tuesday, October 8th for Srikumar Rao, Dealing with Challenges Ethically, or also known as Dealing with Reality. Srikumar is the Grand Master of that. We look forward to that presentation. And then a spectacular presentation, October 10th, that is What Jonathan Blockmacher is Thinking. And if you've ever been around Jonathan Blockmacher, or you've seen him speak, or you've spoken with him, you know that that is always a very enjoyable roller coaster ride. Finally, if you want to add $50,000 a year to your income, if you have an extra half hour, Thursday, October 17, my friend and best-selling author, David Finkel, going to talk about 5 easy ways to increase your professional practice's profit by $50,000 or more. Please also note, November 7th and 14th, we're going to be talking about charitable giving with Michael Lehman. Those are going to be very, very interesting sessions, and of course, a lot more are coming. Barry Flagg is a very impressive professional and also a friend of mine. In 1987, he was the youngest candidate in recorded history for the College for Financial Planning to complete the CFP educational program. Barry thinks like an actuary. He communicates as good as a lawyer, I'll say, and has a tremendous passion for making sure that people and their insurance products are well-matched, logical, and competitive. Barry, as I said, could you tell us a little bit more about your background, because it's really unique for what you do?
Sure, Alan. I started my professional journey in the investment business, in the fiduciary investment business, as an analyst in a pension investment advisory department. So my indoctrination to the financial services business was in a fiduciary environment, prudent process and all. I thought that's the way the whole financial services business worked. I had that position while in school, working in a firm that my father started, wouldn't let me work for him. So I worked for the partner who was in charge of the pension investment advisory department. When I graduated, I went to go expand my experience and diversify my resume. I went to go work for a life insurance company, again as a quote unquote analyst, and was told the way that you do the way you do due diligence on life insurance products, the way you document your decision support, is you run one sales proposal, which is never to come true, and compare it to another sales proposal, which is never to come true. And that's what the insurance industry called due diligence or decision support. And coming from the fiduciary environment first, where I was using Morningstar to look up cost and look up performance as an independent measure, that never made any sense to me. So you fast forward some years, I started this company called Veralytic, which provides any financial advisor, insurance professional, attorney, CPA, CFP, with the same information that Morningstar provides for mutual funds, Veralytic provides for life insurance.
Very impressive. And
Thank
the
you.
Veralytic platform is really neat. If you're a lawyer or a trust officer or a CPA and you want to learn about an insurance policy, you can email Barry, and he's got a really nice program at Veralytic that will give you instant and very, very interesting information about that policy and competitive policies. So Barry, let's take off, and what are we doing?
So this New York best interest rule for life insurance, which is the first of its kind, I think raises interesting considerations, maybe even a dilemma for fiduciary advisors, for estate planners, for lawyers. For instance, I'll put it into kind of a analogy context. there's no real discussion about a client who engages an attorney or an estate planner to do estate planning that involves an asset protection trust. And if you do that, there are certain jurisdictions that are better than others for asset protection trusts. And if you didn't know what those jurisdictions were and you were and what the advantages were, then I don't know I think that would be an ethical dilemma for the estate planner or the attorney, because certain states have clear advantages over other states for domiciling an asset protection trust. Am I on track with that, Alan?
Absolutely. And you've named the good states too: Nevada, South Dakota, Ohio, and there's more and more of them.
Yeah. And similarly, I mean, if you're doing estate planning and it involves dynasty trust, same thing applies. That there are jurisdictions that are just better for a dynasty trust than others, and it would be kind of a ethical dilemma, or certainly an issue, if an estate planner wasn't looking at the advantages of these jurisdictions. So if you think about what this New York best interest rule introduces, New York has issued a best interest rule for life insurance. It only applies to New York related business, and I'll get into further detail there. But from an estate planning perspective, is there an ethical dilemma or consideration for domiciling ILETs in New York? And I know there are other problems with domiciling trust in New York. Taxes aren't all that favorable and some other things. So maybe not actually domicile the trust in the ILET in New York, but New York has these rules that are not applicable in any other state. So maybe it's just a ethical consideration to work with life insurance professionals who are licensed in New York, who are at least familiar with the rules, or if not working with a life insurance professional licensed in New York, at least is there some duty or consideration for estate planners to at least say, look, these New York, which has a track record of issuing kind of a first mover track record of issuing important insurance regulations, there are these best interest rules in New York. Do estate planners have some duty or consideration to communicate this to clients? I'm not an attorney, so I don't know, but it seems like it would be in the client's best interest to at least know about these rules. So I'm going to talk a little bit about the rules, and I'm going to contrast them with the rules in every other state. So this Regulation 187 in New York redefines the meaning of client's best interest for product recommendations. It does so very much like other fiduciary rules, where the recommendation must consider only the interest of the consumer or the client in making recommendations. It must be based on careful, skillful, prudent, and diligent evaluation of the client's circumstances and of the elements of the product, and it must prominently disclose in writing any limitations in the range of product recommendations. So that sounds a lot like a fiduciary standard, and then we'll come back to what other states, what the regs are in other states. Product recommendations also need to be based on the evaluation of all products and services available. Now, there's some question as to what available means. That has not been clarified to my knowledge yet. Does that mean available to the producer? So if he's licensed for one insurance company, does it have to be all the products of that insurance company, or does it have to be all the products that are available in the state? I think that gets back to the last bullet on the prior slide that says if there are limitations, you got to disclose them, and those two provisions work together. You have to consider relevant suitability information. So in New York, the process doesn't start with the flavor of the day product. It doesn't start with the latest, greatest illustration. It starts with a requirement to ask 13 suitability questions, and then it requires the producer to consider the costs and whether they're justifiable relative to those suitability considerations or suitability factors, whether performance is reasonable relative to risk that's appropriate to the client. So again, sounds a lot like a fiduciary rule, but it only applies to residents of New York, former residents of New York who may still have ILETs in New York, trustees in New York, even if the ILET is domiciled elsewhere, or financial advisors in New York, or with clients in New York. So outside of New York, these considerations, as we'll see in a minute, aren't really considerations. So from an estate planner's perspective, who has a fiduciary relationship with their client, is there some duty or consideration to think about New York, either to domicile the ILET or to work with producers who are licensed in New York, domicile the ILET in New York, or work with producers who are licensed in New York, who are at least familiar with these, have to be familiar with these rules, or at least inform the client that there are these different standards of care in New York, and you might want to either find a producer in New York or domicile your ILET in New York. So outside of New York, all other states are following what's called the National Association of Insurance Commissioners illustrations model regulation. It's defined clients' best interest for product recommendations since 1995, with a goal to ensure that illustrations do not mislead and make illustrations more understandable. And whenever I give this presentation in person to a live audience, I always get a chuckle because for the last 30 years, that just hasn't come true. In fact, it hasn't come true so much that the NAIC even concluded in 2015 that it has resulted in a lack of uniform practice, resulting in illustrations that use apparently apples to apples, but are really apples to oranges. So the NAIC regs are intended or define clients' best interest in a way that lacks uniform practice. So the effort of comparing one illustration to another illustration as a proxy for comparing costs lacks uniform practice, which means you're comparing apples to oranges, even according to the NAIC. Every fiduciary principle that I know of includes a consideration of costs, performance, and risk, and the NAIC illustrations model regulation includes no requirement to disclose costs, nor performance, nor risk. And for these reasons, among others, the chief regulatory body of the financial services industry says that it is inappropriate to compare one illustration to another, even though that's what the NAIC has been endeavoring to do or endeavoring to make possible for the last 30 years, because comparing those without comparing the things that fiduciaries consider, like costs and expenses, is misleading. Even the chief actuarial body of the life insurance industry, in a study years ago that has been largely ignored, said that comparing illustrations for decision support on policy selection is fundamentally inappropriate, and the chief regulatory body in the land, or the regulatory body of the largest group of fiduciaries in the land, the OCC, Department of the Treasury, the U.S. government, says that these illustrations are subject to a high degree of fluctuation and therefore not very reliable for decision support. So for those who have a fiduciary orientation, who therefore embrace the careful, skillful, and prudent evaluation of cost, performance, and risk, comparing illustrations are going to be hard to defend as decision support now that they're considered misleading, fundamentally inappropriate, and unreliable by three industry bodies charged with protecting the consumer. I've written about this in a piece, in a commentary for Steve Lineberg, and in that commentary there is an example that illustrates just how misleading, fundamentally inappropriate, and unreliable comparing these illustrations can be. There is a real-life example where two illustrations actual illustrations from actual insurance companies are discussed in how they are frequently used. The first illustration had a premium of $13,000. The second illustration had a second illustration. Where's it going here? There we go. Sorry. The second illustration had a premium of $8,500. So anybody who is thinking that illustrations are a proxy for cost, and as you can see in the Lineberg commentary, everything was made apples to apples. The rate of return was the same, the age was the same, risk class was the same, face amount was the same, premium payment period, everything was the same, apparently. And if you make everything the same, then premiums are a proxy for cost, for finding low costs. And here the universal life policy clearly has lower costs with a lower premium of $8,500. However, if you look at, and I would urge, in fact, insist, I urge anybody on this call, I insist any of my fiduciary clients, customers, to ask for what are commonly referred to as detailed expense pages that show the year-by-year disclosure of costs for each policy. If you look at the costs for each of these two products, each of these two apples-to-apples comparisons, the costs in the indexed universal life policy are $822,000 over the expected contract term, and yet the cost of the universal life policy that has lower premiums is actually $1.1 million. 50% more. So how is it possible that if everything is calculated the same, that the product with the lower premium actually has 50% higher costs? Anybody with any math sense knows that it can't be true. And I talk about why that isn't true in the Lineberg piece. But I'm going to kind of skip through it here because in the interest of time. So if these illustrations are misleading, fundamentally inappropriate, and unreliable, according to three different industry authorities charged with protecting the client and the consumer, I as a fiduciary, I serve as sub-advisor to a couple thousand life insurance trusts. The very first thing I tell my trustees is, do not have illustration comparisons in your file, because you just don't want to argue that something that three industry authorities say is misleading, fundamentally inappropriate, and unreliable was your decision support for prudent, for a skillful, careful, and prudent selection of a product. Instead, at a minimum, insist on having the detailed expense pages in the file. The pages that show that you actually did look at not these misleading hypothetical calculations, but the actual cost, that you actually considered costs, which if you're a trustee of a life insurance trust, Section 7 of the Prudent Investor Act, as may be adopted in each state, says that you have to consider costs and you have to justify costs. So if you have the detailed expense pages in your file, at least you can demonstrate that you considered costs. If you're going to compare illustrations, don't compare hypothetical values. Compare the cost pages, and compare costs and performance separately. As you'll read in the Lineberg piece, when you actually do compare cost and performance separately, I think you'll find many of you will be very surprised at what you find. But when I was a 19-year-old kid in college working in a pension investment advisory practice, what we used to do was we would benchmark. We would benchmark the costs, benchmark the performance of a mutual fund against the S&P 500 if that was the appropriate benchmark. And we would benchmark costs of a particular fund against what Morningstar would say was the average cost or the low costs or the excessive costs. Benchmarking is well established and common in just about every other sector of the financial services industry, and that's what Veralytic gives you the ability to do. Veralytic benchmarks the financial strength and claims paying ability of the insurance company. While that information is available elsewhere, it's all packaged up into readily acceptable or generally acceptable star rating of overall competitiveness. It measures the cost, which is one of the things we have patents on, and is the only place you can get a measurement of costs against the universe of peer group alternatives. It measures the stability of those pricing representations. It measures or considers in the overall rating how accessible are cash values. In an ILET, maybe cash values are incidental or unimportant to the purpose of the plan. And so maybe cash values aren't important, so maybe that consideration is not relevant in a given planning situation. But if you're going to give up cash values, I'd hope you'd get something for it. If you're going to give up, if you're going to accept restrictions on your access to an account, like in a hedge fund, you do that because you want a higher return. Well, in life insurance, if you're going to give up liquidity, maybe you should get a better price, which you should. And the last thing we measure is actual, or benchmark is actual historical performance of invested assets underlying cash values, which to me is the most inexplicable. That everybody asks, if they're talking to an investment advisor, everybody asks, well, how does the actual historical performance of this mutual fund compare to the S&P 500? But nobody, at least in my experience, nobody asks, well, what's the actual historical performance of invested assets underlying this cash value? And how does that relate to this hypothetical projection that we're talking about? But you can get that information from Veralytic. The greatest unknown, though, while it's inexplicable to me that people don't ask about the actual historical performance of the assets underlying life insurance policy cash values, the greatest unknown is cost competitiveness. It has been published in a number of places that the variance between competitive pricing and excessive charges is as much as 80%. In other words, some of your clients who are the same age, in the same risk class, same gender, they could be charged twice what some of your other clients could be charged. And that's been published in a couple of other places. That information is maybe alarming, but not useful until you know where the average costs are. So where the benchmark is. So with Veralytic, you know where the average costs are for a given situation, and then you can apply the 80% variance around that average, and with that, what products, what are the worst available rates and terms in the marketplace, what's the highest costs, what's the lowest costs, what's the best available rates and terms in the entire marketplace, and then you can consider in less time than it takes me to explain this, whether or not the cost of the policy under evaluation, whether your client's cost, the cost being charged inside your client's your in-force policy, or the cost being proposed to your client, whether or not they're competitive or not. Again, in less time than it takes me to explain that. The power of benchmarking, which again, as a 19-year-old kid, this seemed to make a lot of sense to me, and was certainly a lot of the motivation behind my invention of Veralytic. Alan, how are we doing on time?
Very good. I'd say you've got about 10 minutes.
Okay. So the same principle applies to the benchmarking of returns. And with the current version of the best-selling product right now, Indexed Universal Life, this is very important. I don't know if it's important as the cost equation. Actually, it is just as important as benchmarking costs. And this is discussed in the Steve Leinberg piece as well. The actual performance of a life insurance policy is going to be driven more than anything else by the risk tolerances of the client, the asset class preferences that correspond to that risk tolerance, the time horizon that we're expecting our returns over, and what's reasonable to expect in terms of the outcomes. That's true not just for life insurance. There have been a number of studies that say that the asset allocation is the largest driver of overall return. So even though some of these illustrations, I mean, I've seen whole life illustrations projecting a dividend interest crediting rate of 8 or more % over decades, even though they are required by whole life policies and universal life policy for that matter, are required by regulation to invest in high grade bonds and government-backed mortgages. And even though the historical return for high grade bonds and government-backed mortgages is on the order of 5%. So once again, it matters not what the illustration says. That is a hypothetical projection, which everybody knows is never going to come true. So what is reasonable? Well, benchmarking costs and performance separately says, okay, now I know what I'm being charged. What is reasonable to expect in the way of performance? Well, if it's a whole life policy, probably 5 to 6%, because whole life policies by regulation have to be invested in asset classes that have historically produced 5 or 6%. If you had a little bit more, a client with a little bit more aggressive risk profile, maybe indexed universal life, which still invests assets, underlying cash values, are still invested in high-grade bonds and government-backed mortgages, which is not well understood by too many in the life insurance industry. Indexed universal life cash values are not invested in any index. They're invested in high-grade bonds and government-backed mortgages. Only the interest from the high-grade bonds and government-backed mortgages can be used to buy options on the index. But because you have an option to get some participation in an equity return, there's a reasonable argument that says you should get some lift over what you would otherwise get from high-grade bonds and government-backed mortgages. But just like anything else, if you have an opportunity for a higher return, you also have some more risk. You have risk that those options will expire out of the money and you'll get nothing. So your return will be less than what a traditional whole life or a traditional universal life policy would be. And the same thing holds true if you allocate 100% of the cash values to emerging markets or international stocks. You've got more risk, you've got more volatility, but you have the potential for a higher return. Why this is particularly important now is many an indexed universal life illustration will show prominently on every page of hypothetical values. So if you can picture in your mind's eye one of these illustrations that has a bunch of hypothetical policy value numbers on it, hypothetical premiums, hypothetical cash values, and then in the column headings above those hypothetical numbers, there's almost always a rate of return. And any reasonable person would assume that the hypothetical values below that rate of return are calculated using that rate of return. Well, what a Veralytic report will reveal for you that is not otherwise apparent is, in this example here, the illustration showed a 6.09% rate of return, crediting rate, above the hypothetical values, but buried deep in the footnotes and revealed on the detailed expense pages, which is one reason why I urge everybody to get the detailed expense pages. And if you're a fiduciary, I would insist on getting the detailed expense pages. On examination of those pages, you'll actually see that the interest rate required for that product to perform as the client expects is not 6.09, but 10.7. And as we talked about earlier, 6.09 may be a relatively conservative or a rate of return that corresponds to an asset allocation that corresponds to a relatively conservative client investor risk temperament. But a 10.7% rate of return would be an aggressive rate of return. So if you've got a indexed universal life illustration that shows 6% and a client is expecting low risk, they're actually looking at something that might have some high payoff, but it's got a much higher risk that it's never going to come true. I'm not saying it's not going to come true. It's just got, if you believe in modern portfolio theory, it's got a higher risk that it's not going to come true. So just important to know. So again, all of these things, I think, introduce ethical considerations or even a dilemma to fiduciary advisors who have duties to exercise care and skill and prudence and diligence in their evaluations of and their decision support of a product recommendation, like the things we talked about here today. And that benchmarking is used in just about every other segment of the financial services industry. Benchmarking costs separate from performance is the prevailing practice in every other segment of the financial services industry. It's consistent with the New York Best Interest Rule. It's consistent with FINRA requirements. So why isn't that good enough for life insurance? And why shouldn't that be the way that any fiduciary? I understand that salespeople do not have the brokers do not have the same considerations, but any fiduciary advisor, why would you not be looking at the benchmarking of costs and performance separate from each other, and not getting away from these illustrations? So should ILETs be domiciled in New York because of this New York Best Interest Rule? There are certainly other considerations that impact the decision of where a trust should be domiciled, income taxes, and other statutory considerations. So I'm not saying that ILETs should be domiciled in New York, but for the same reasons that you would consider domiciling a asset protection trust in Alaska. Did I pick the right state, Alan?
That's Alaska, a good one.
Alaska, or a dynasty trust in South Dakota. I think you got to have the conversation with the client about New York State has regulations that provide you as a client with an ILET, protections that are not available in other states right now, and protections that, as we've seen here today, can be significant. So should the ILET be domiciled in New York? I don't know. But if it's not domiciled in New York, then should the client at least consider working with a life insurance producer who's licensed in New York and therefore has to at least be aware of these things and not following this NAIC illustrations model regulation, which is now considered misleading, fundamentally inappropriate, unreliable by three industry authorities? And if not working with a producer, at least tell the client, that there's this best interest rule. It's different from the way the insurance industry has been regulated in the past. These regulations may afford you with additional protections of your interests that are not protected in other states. So maybe you should at least have that conversation with whomever you are working with. Alan had asked me to. Alan, do you want to talk about this, or you want me to talk about this?
You go ahead and please make the offer.
So our research is useful to anybody in the fiduciary space. Clearly, life insurance trusts, whether I work directly with life insurance trusts, but even if you're working with somebody else, benchmarking the way we talked about for the reasons we talked about is important in the performance of careful, skillful, and diligent evaluation of products. Veralytic, Veralytic is available for a fee. Anybody can get it. Accounting firms can use Veralytic. Law firms don't typically subscribe to Veralytic, but oftentimes will recommend that their clients get a Veralytic report, particularly when they're getting proposals from different brokers. Which one? How do you know which one's right? How do you know which one actually has low costs? Well, you can get a Veralytic report for a very nominal fee and kind of get insurance on your insurance decision or verification of your insurance decision. I'm happy to provide so that you can get an appreciation for just how different the information that you get in a Veralytic report is from comparing hypothetical illustrations. I'm happy to provide any listener with a complimentary Veralytic report. just go to just Google complimentary Verilytic report. You should be brought up to this page on our website, and it'll ask you, or in the instructions, it'll tell you to include with your report request and your submission the name of the conference or webinar. Just include Gassman 2019 in with your submission, and I'd be happy to get you a Verilytic report at no charge, and even spend a few minutes going over it with you over the phone.
Thanks very much, Barry. That is very, very generous of you, and you've been very generous of your time both today and in an unlimited number of times that I've called on you to help me understand. That's for sure. So Barry's email address is there at the bottom, bflagg@verilytic.com. Please don't hesitate to ask Barry any questions you might have. And please don't forget to join me with Srikumar Rao Tuesday, October 8th, Jonathan Blotmacher Thursday, October 10th, David Finkel Thursday, October 17th, and many, many more times as we bring you continuing education and hopefully entertainment and useful information. Barry, thanks again, and I hope everybody, that the rest of everyone's day is billable.
Have a good one. You too.